Thank you so much for joining this webinar. And we would like to welcome you at today's webinar, which is going to discuss safe recruitment and legal aspects. This webinar is going to be conducted through an hour with a discussion and answers frequently asked questions. We are going to ask some of the attendees, and we're going to leave space to answer all your questions and requirements. Safe recruitment is considered to be one of the crucial topics that should be highlighted, and we should focus on legal aspects as well related to this process. This webinar is going to handle a detailed discussion about SIA threats or sexual harassment, and how to have a safer recruitments and how to process these harms, and because this, of course, empowers the quality of work environments. And of course, we are going to pay attention to legal aspects of the recruitment office. And this is a sequence of dialogues or discussions that we are going to provide you all with through the dialogue and through the reports that we send to all of the members by the RSH. My name is Omar Qawasmeh, and I am the Jordan country representative for RSH. And of course, I'm going to start with the instructions for this session. This session is going to be conducted in Arabic, and we have interpretation options in English. So please provide or choose the interpretation that you like, which is underneath the screen. And of course, we would like to ask you to be muted with no cameras, just to guarantee the quality. We are going to record it and post it on our platforms and websites. So yes, please. If you have any questions or requirements, please write it in the chat box during the session or raise the hand, and we are going to answer in the specified time. In the last 5 minutes, we are going to have some questions, both in Arabic and English languages, and we hope you answer as a feedback that will help us increase the quality. Good morning once again, and we would like to introduce our dear guests. We have Ms. Heba Odeh, and she's the human resource specialist. She has more than 15 years of experience in human resource departments, and she's passionate about different fields like working in a humanitarian, local, and regional fields, and she has collaborated about political policies and procedures and running the human resources departments, and of course in SIA field as well. And she's experienced in some initiatives, change initiatives, and conducting safer recruitments. And of course, we have Mr. Muath Momani, a lawyer consultant specialized in different fields and CSOs. And he's, of course, he's member of the RSH Jordan representative, and he's working as a legal consultant with different organizations, local and international organizations. And of course, he provide a good help in raising capacity of people. We would like to welcome you, our dear panelists. And of course, we are going to start with Ms. Heba. In your own opinion, to be able to be part of a safer recruitment, let's say policies against harassment or SIA, why should we focus on safer recruiting or on safe recruiting? And how is it possible to guarantee that? Please, the floor is yours. Thank you so much, Omar, and good morning or good evening, depending on your place, for all the people interested in being with us on this webinar. This webinar, as Omar said, is going to be conducted through an hour. Your question is very broad and general, but the presentation that I'm going to cover is going to provide the answer in this webinar, and hopefully it's beneficial and full of information as everybody expects. And hopefully we are going to go through different stages that is related to safe recruiting, and just to get to know how can we guarantee a safer recruitment environment, what is the benefits, and what are the stages that we should focus on, and on each stage how are we going to make sure that we are conducting a safer recruitment policies or a safe recruitment, whether we were in an NGO, international organizations, local organizations, or CSOs. So just to answer your question, your general question, Omar, there should be a presentation, and I believe, or I hope at the end of this presentation that I'll be able to answer your questions. So first and foremost, safe recruiting is one of the most related to HR topics, but it's the most important because it focuses on the first procedure, or let's say the first step for recruiting staff to be part of the family of this institution or organization, which is the first stage that we pick this person to be part of our family? How is he a supporting member to save or to achieve a safer environment? So when we would like to speak about safe recruiting, or what are these safer practices, safer recruiting practices, it is a process that is inclusive. The reason here is that we would like to deter people who are unqualified to be in our working environments, or they are unqualified to be a part of this organization. They cannot attain these safe environments. The importance here is that the basic or the crucial point for all organizations, since we are dealing with vulnerable communities and let's say beneficiaries, we are looking to establish safer organizations supportive to their partners, members, staff, or even the communities that they deal with. So this is the first procedure, the first step by the Human Resources Department to select and pick the rightful people to be part of this organization. The mechanism is inclusive, as I mentioned earlier, but the essentials or the basics that guarantee that we are hiring the rightful people or the suitable people starts with the Human Resources Departments. The essential block is to gather information and data about people who are applying for vacancies. We analyze these information, we compare these information through job applications by applicants. We go through so many details and from human resources perspectives, which include the experiences in the curriculum vitae, specific dates, what are the parties that this person has worked with before, what are the vacancies that he worked, what are their experiences. And it doesn't end here. It moves from human resources partially to the direct director after this person has joined, or let's say, whether it's a male or female, to the organization, where there is a role for the direct director to make sure that this person respects and abides with all the internal policies and procedures, whether he was inside the organization or outside. And these policies are always applicable and always applied as long as this, let's say, this staff member is working within the local or international organization. So let's now start talking about the mechanism, the recruitment of application. It's inclusive for all the hiring cycle, which is divided into 8 different parts, 8 different stages. We are going to speak in specific about each and single one of them. The first step, which is the job description and conducting the job announcement, is the second stage. And then we have the shortlisting, interviews, checking with the list of reference, contracting, identification, training, and qualifying. Some of us here, we are used to different terminologies, or we are more familiar with the English terminologies, especially international organizations, where I'm going to mention them both in English or Arabic, just to be on the same track or on the same page, to try to link them with different stages. But this is very important to be mentioned in Arabic language, because originally we would like to cover different categories for all organizations, whether they were local or international. The first step, which is the first procedure, when we identify that there is a vacancy, I'd like to prepare the job description for this job. It's very important to mention, let's say, that this organization or this institution has a specific code of conduct to indicate the values, the vision of the organization, and to make sure that I'm clear to specify the responsibilities of this person or this applicant, and policies and in safeguarding policies for this work environments, or do no harm. This is how is it familiar and known. Do no harm is very familiar in organizations and institutions. And in job description, we should state the responsibilities in general, and we should focus on the obligations that has to do with safeguarding in this, let's say, and protection in this vacancy. If this employee, whether a male or female, there are some obligations that they should augment and enhance through the vacancy that they are going to fulfill. And of course, we should indicate 100% about the duties, the role of that person to augment, to enhance, to abide by these or fulfill these obligations. And some vacancies we should mention. Some vacancies are leadership vacancies, and they have more specificities when it comes to mentioning the obligations that has to do with safeguarding, protecting from the place or from the role of that person in the organization or institution, we focus more and we add more pillars in the job description that has to do with safeguarding policies that maintain and the obligation of safeguarding policies and the policies that has to do with internal code of conduct. After finishing with the first step, we move on to the second phase, which is called the job announcement or declaration, and is going to be through different channels, websites, or let's say printed out and is put on CSOs, or despite the fact of the way, we should make sure that these announcements is inclusive and it clearly include a statement that indicates the obligation of these institutions, that we have a specific code of conduct, we have an internal code of conduct, we have internal policies that has to do with safeguarding, and that goes against sexual harassment and exploitation, that the applicants should know that this organization adopt these kind of policies. After finishing the job description and announcing for the job description for the vacancies through different channels, we receive so many applicants usually about the declared and announced jobs. The third phase is to make or to establish a short list that has to do with human resources departments plays an important role in this phase. When we receive all these kind of applicants, we should revise these applicants, bearing in mind that safeguarding concept is there, and we focus on specific details that might give us an indication that this person is a fit in this position based on its experiences and what are the qualifications, the needed qualifications. I'm going to mention more details now. So the human resources staff responsible for staffing or recruiting is going to focus on specific points or pillars through the process of revising or revision. The first thing is education, experience. Is it a fit? Is it suitable for the vacancy? And the dates, of course, the history. Does it make sense? Is it logical or illogical? Sometimes we see some curriculum vitae with very, let's say, wrong dates or a short period of time, or even certificates, diploma that is with a short period of time, or even very long period of time, which indicates, let's say, a bad omen, or like, yes, a bad indication. When it comes to the record of staffing for that person, if we've seen that there are some gaps, he hasn't been working for so long, or he is working for a short period of time in each organization, this is considered to be a red flag for so many things that we have to focus on. This is why we keep this information if he's a fit and if he's competent, but we ask this person after being hired or in the stage of interview, just to get to know why does he have these kind of gaps. And the third important point here, and not all the organizations needed by all the organizations, but some organizations as part of the application, they ask for a reference lists or references. Now we are speaking about the short listing phase. There should be a references. This references it consists of two persons at least, and one of them should be a stockholder or a direct. Some people ask it in different stages, but it's part of the application, just to make sure that this person has no problem in providing these references in the application form. Another part of these stages and phases, in some organizations or institutions, they ask a self-declaration form. Self-declaration form is considered to be the query with a specific information by the applicants. Sometimes it's through the application process. Some organizations ask from applicants after being selected and succeeded in the hiring process before the offer of the job. And this self-declaration form, I'm going to mention some things about it. Some specific information are asked, and they will sign that all information mentioned below are correct and that he's accountable of it. Okay, usually when there is a person that sees that this organization has a self-declaration form, he knows that this organization takes the safe recruiting and safeguarding process as serious as possible. He knows that there are some obligations that he needs to fulfill. If we didn't have a self-declaration form as an organization or even institution, and we would like to conduct one, the first advice is that we should go back to an experienced legal background person or a legal, whether a lawyer or a legal consultant. And of course, Mr. Muath is going to add more to use that the used language in this form is in align with the reason and the purpose that I would like to serve. The information mentioned in this form, the self-declaration form, some specific information regarding some questions. As recruiting staff, what's important for us? Is this person fit to work in these organizations with vulnerable groups, for example, women, children, elderly, and some emergency cases, people with disabilities. So is this person, he hadn't have any penalty with any committee or organization, and he signs that all information are correct and credible and of course precise. We ask this person, once you sign this contract up until you've reached the hiring, if any of the information or details was changed, you have to go back to us and you have to update all the information that was mentioned in the self-declaration form. So now, after the self-declaration form, now we have revised the application, we have a short list. Now we have the interviews. We've selected 5 to 7 people, for example, and we've decided to conduct interviews. My recommendation to interviews, just to guarantee a safe recruiting process, that there should be a person at least, or one of the questions has to do with safeguarding. This is the person has no role or direct role with safeguarding. We would like to understand that this person has an inclusive, comprehensive idea about safeguarding. So if this person's role has to do a lot with safeguarding, or he's going to be dealing with beneficiaries directly, or he's going to be accountable at some point, we should know that he recognizes and understands the policies and principles of safeguarding, and how is he going to deal with the communities he's going to be with them. So we add further details and information, or even questions about safeguarding. The questions that has to do with safeguarding policies or protection in general we should read. There should be various kind of questions, but as a human resources staff, we should read what are the motives to be part of this organizations. What are the motives? What are the reasons? And to what extent he understands the demeanor, the behavior? How does he understand the values? How does he accept the organization through working with beneficiaries or even the communities that we are serving? So many problems that we face sometimes, that the person couldn't differentiate whether this behavior is accepted or unaccepted. So this questions makes us understand to what extent he understands the policies and what are some accepted behaviors, unaccepted behaviors, going back to the internal policies of the institution or organization. Another part of the interview should be an indicator to the values and the code of conduct or safeguarding code of conduct to this organization. He should know that we have policies related to this subject. We are committed, we are obligated, and you are going to be part of this obligation. The human resources departments or people responsible for hiring or recruiting, in the problem in shortlisting for candidates, if there is any question, comments, inquiry, or vague, let's say, about the curriculum vitae, he should ask about it in the interview, because this is something that is going to lead us to another issue. We're going to check through the references provided by the candidates if we have felt that this information wasn't clear, wasn't enough. And the HR staff might read that this is a red flag or an indicator for a danger or something, or accepted or unaccepted, or indicates something else. And we know, of course, that this person might be subjected to accountability, or he doesn't understand what's the meaning of these policies and how to be fulfilling for these obligations and policies. There should be questions that has to do with, let's say, safeguarding and how to inline and work with adults and children. We are speaking about all the vulnerable categories: women, children, and elderlies. And of course, interviews should consist of 2 experienced. One of them should be part of the human resources departments. Some parties couldn't provide these things for some hard circumstances, like an HR staff can't be part of this committee. In this case, and we do not prepare this scenario, there should be an HR staff or an HR member, which is part of the interview committee. If he couldn't be there for any reason, this person might engage with the committee that interviewed the candidate and to make an evaluation and assessment and to see any questions or anything or any requirements to know about through a contact or a follow-up process after the interview. There are so many details, but I'm trying to cover as much as possible of the information that we need here. And hopefully, I hope that everyone is focused and following up with me. So after the short listing or the short list and conducting the interviews, we've decided to pick some candidates. I'm going to say that this policy or this approach is called, or it's applicable not only on the staff, but any person who's going to work in the organization, whether a volunteer or a consultant, or despite the fact, or different contracts. So as part of, let's say, the hiring process is to ask some references. And as I mentioned before, there should be 2 people at least, or 2 references, to ask more about that person, to have as much information as possible. And this, let's say, the information that we receive through the references should be satisfactory for us. Usually the organization or institutions have special or specified principles, not things that has to do with safeguarding principles, that this person hasn't have any, let's say, warning or anything that had to do with violating some internal laws and regulations, the things that are considered to be red flags that we wouldn't consider in our organization, and we would not accept. The number of references differs from one organization to another. As I mentioned, as a recommendation from my side, I prefer 2 at least, but let's say which is accredited or conducted. And of course, there has been a debate. They are asking for more references. These references might include not only direct directors from different places, but also asks for a personal reference, at least, just to know about the person, not as a professional member of an organization, just to know more about him as a personal life, as a colleague, as a friend. So these references is preferable to be revised by the Human Resources Directorate or director, excuse me, to just to see that it goes in line with the principles of the organizations. We should pay attention if we have seen that there are some negative indications that this reference is short, or he's not trying to fulfill some information. He rejected to give some information about the person. In this case, we should follow up more, and we should, for us, it should be a basic to take a decision that we are not going to move forward with the application of this person. Any party or any field that works in Jordan, whether it's an organization, institution, or even a private public company, we ask the applicants a good conduct. A good conduct, of course, provides that this person has no criminal records on the country level. Contracting or contracts. Contracts should be after conducting all the requirements, after having all the information. And this includes, of course, the background, asking about the references, about the criminal investigation record for this person. He has nothing on a country level. After that, contracting. The contracting that should include a pillar which indicates that this person, volunteer, consultant, should abide with the obligations, the policies, internal policies, and the code of conduct, just to be able to take any procedures if he wasn't abiding for these obligations or he was not fulfilling the obligations. We have an internal policy which is approved by the Ministry of Labor for all ministries and organizations, which is going to be responsible, or a reference for us to decide that we would like to end or resume this contract because this person violated something or some pillars in the contract, or we might dismiss this person, and we are going to dismiss this person. And Mr. Muath, of course, is going to mention The 7th and 8th phases, of course, speaks about the identification or induction and orientation. A person should receive or read and be introduced to the internal policies for organizations and safeguarding policies and the internal code of conduct that helps us to ensure that those people comprehend the internal policies. These policies should be assigned and approved in the person contract. In case he violated, we, of course, we make sure that this person understands it. And of course, the recommendations to have a specific time frame. This person should finish these trainings in a period which is no longer a month, and this should be a decision taking amongst the two parties, because it might affect the assessment of that person in the probational period. And we should share with those people the list of contact that they might report, or they would like to know more.
كل 6 شهور لجميع الموظفين عشان نتأكد انهم فاهمين السياسات الداخلية تبعتنا ومعلوماتهم.
Or they are facing some obstacles, or they need some help. So please just tell us from your own experience about the less resourced organizations. Yes, they are. We couldn't provide all of this information in civil society organizations, but I imagine that with the participation of different different information, there should be a long-term plan to see how are they committed to these recommendations. But on a short dimension is a whole process. We should focus on the most important parts, like references, very important and crucial from the person we have decided that it's going to be part of the organization. So many organizations like the RSH for safeguarding RSH, you are conducting this kind of things like a free service through the postal service, some training about safeguarding that is used with these organizations or CSOs, which is unpaid service, but the staff should be committed to fulfill these trainings through a period of time, and it will be gradual to give them different trainings from different resources, which is the least things to provide for them. Thank you so much, Ms. Heba, for this great answer. Thank you so much. Now we are going to move to Mr. Muath. We would like to welcome you once again. Mr. Muath, as Ms. Heba mentioned about the importance of safe recruitment, and of course, this is very important topic, and it guarantees to have persons that's been hired correctly, which guarantees to mitigate exploitation, whether sexual exploitation or harassment. Of course, Mr. Muath, especially you are legal consultants and you are working with CSOs. The main goal is to reach a safe working environment, whether to the beneficiaries or even the staff. So based on what Ms. Heba mentioned about the safe recruitment, how is it possible to save the organization or to protect the organization legally to have a let's say, safer legal procedures and recruitment. Good morning, ladies and gentlemen. Good morning for everyone participating in this webinar. And as a matter of fact, it's very important to clarify that the Code of Labor or the labor resolution is very important for everyone and anywhere, because this Code of Labor or the labor code has a social, let's say, connotation, because we are workers or stockholders, we are directors, or even we are staff members. It's crucial and essential for all CSOs, whether they were local, international, national, international, in different, let's say, backgrounds. They should pay attention and take into consideration the labor code or the Code of Labor, and to extend that and to provide a specific principles for the decent working environments that's been indicated in the International Code Labor of Code. As a matter of fact, my colleague Heba mentioned so many details that she can't give parts without speaking the legal aspects. The legal aspects when it comes to recruiting and the administrative parts that our colleague Ms. Heba mentioned is very important, but the legal aspects, there are some legal aspects that should be covered, which are considered crucial and essential. And from my own perspective, they should be contextualized and that the administrative and legal aspect should be parallel, as she mentioned in the documents, and providing documents that the workers provide for each organization or even information. This is very important and crucial, because unfortunately, I don't want to say the most, but probably about some details Heba mentioned that has to do with the time frame, 100 hours in 2 days, for example. All these subject the worker to be in a place or to leave this place without having any rights, any worker rights, which is providing incorrect or forged documents, and he's going to be held accountable. Article 28 of Code Labor to be dismissed without attaining any working or worker rights by the labor resolution through providing incorrect documents, or sometimes through providing forged documents. And even the recommendations that are provided probably, for example, with all due respect, Omar is a friend to give the recommendation or people about the new job vacancy announcement. And now I am subjected to an investigation because of that an act which is considered unethical, and of course it violates all the code of conduct inside the institution. And Omar, of course, might be a friend or has nothing to do or not interested in that there is an investigation that's been conducted. And I believe that this issue, Heba, of course, might heard about this. There are some institutions today that are directing into having some notices or a momentum of understanding between these, let's say, institutions, where since Mo have provide this person from this organization is of course obligated to give a summary about the job file about Muath while working in that organization, and not only the references. So we're taking from the organizations. Please, I would like to interrupt you, Mr. Muath. What you are mentioning here is that we can dismiss the employee if we indicate that he has provided forged documents or incorrect documents. Yes, of course, he is to be dismissed. As mentioned by Ms. Heba, of course, before signing and contracting, you have to guarantee that this contract is clear, that the duties, obligations, and requirements are clear, even if it was written in a different language. For example, let's say it was written in English. First and foremost, it's very important to bear in mind that the code, the labor code, I'd like to speak about the Jordanian labor code. Of course, according to Article 3, and just let me take a look, and of course, by the Article 4 of the Labor Code of Labor, the contract should be written in Arabic language. This is according to Article 3 and 4 and Article 15 of the Jordanian Code of Labor. The text should be written in Arabic. And of course, the must information for the NGOs or even the national NGOs to understand English language for the worker. And this is not only to be clear for worker as a contract or different pillars, even the internal system should be clear, or any attachment in the contracts, because there might be a policy for harassments in the contract, or there might be different policies working with dealing with different beneficiaries, let's say working in the field, or even working or engaging directly and daily with different beneficiaries. All these should be clear in Arabic or English. For me, as a legal consultant from different international organizations, the contract should be both English and Arabic languages. The bylaw should be in English and Arabic, and even different policies. And it should be stated to consider that the policy, the harassment policy, should be part of this contract and should be read as a whole, just to be able in one stage, if there has been, let's say, a violation for provisions or for the labor law, that these, let's say, policies are part of the conviction, and we should start investigating or even dismiss the worker services legally. Thank you so much, Mr. Muath. Regarding the policies that you've mentioned, like saving the children, or even any policies that the worker should assign, is it law-abiding? There might be any legal consequences if he wasn't abiding with these policies for harassment, exploitation, or whatsoever different policies? Is it law-abiding? Of course, Mr. Omar, they are considered to be law-abiding. These policies, as I mentioned, they should mention in the contract that these policies are part of the provisions of this contract, and that the worker stated that he understands all the details alongside the internal regulation, and it's very important part. And in case we have violated that, then the labor resolution doesn't intervene in so many details until it has accepted the rights or belittled the right of the worker, which of course achieve the interest of the job and gives equal rights to the worker and to the employee and employer. It's a necessity and it's a part that cannot be divided. And there are some internal laws and policies which go in depth as a worker. Of course, if there is a violation, you don't have the right to dismiss me without going to the internal law, which identifies the relationship between us and which identifies the investigation committee. And as a committee, there should be an abiding or a biased, of course, committee. Thank you so much, which leads me to a very important questions that we would like to ask here. If the human resource person had a claim of harassments inside or outside the job from a director or a colleague, and we have no proofs or evidence, how do we protect the organizations? What are the consequences of the investigation if there are no evidence or proofs? And if there is anything mentioned about confidentiality, especially about the complaints and investigation? Thank you so much, first and foremost. This is an important question, Omar. And thank you. But the article 28 of Code of Labor has obligated the worker, and the worker not only this for the fact that this starting with the executive director to the least people in this, they are all working and considered to be working under the facility and the stockholders. So the Code of Labor has obligated the worker to maintain the confidentiality of that place, like the investigations conducted. For example, if I told them that we are going to investigate because there is a harassment system, a worker, we should be confidential, and we treat it very aggressive, and it's sometimes we deal with it as if it's a jurisdictional or jurisdiction case, and we should maintain the confidentiality not only by the investigation committee. This is the first thing. The second thing, if we found out that there is nothing, like we haven't indicated that the person or who has have the claim, there is no proof or evidence we can protect this organization by, we should have the investigation results in a file of the defendant and defender, because it is going to be an indicator in the future. The defendant, for example, or the defender has given wrong information. This is an indicator at one stage that this person or this lady is lying, or maybe it's an indication at some point that this person the defendant have been filed a complaint of harassment. So we should maintain their files, both of them, as a defendant or defender, and the results, the investigation results, should be maintained as well in different files of parties. And we are going to take into consideration whether there has been a complaint been filed for the same person or the same defender or defendant, that there are some other investigation which is an indication, a situation, an indication that there is an act, or let's say a practice, which needs to be expanded in that investigation, and to take a decision that might be, let's say, unpreferable or against the person who filed the complaint. And on the same time, we should guarantee that the person, the stockholder, the employer, should guarantee the right of the person who have been complained against. If there is no, let's say, for example, or let's assume, yes, everything has been indicated and we have some proofs and evidences. Okay, I have spoken about there is no evidence. What if it was indicated and we have a proof? As an administration procedure, I give a notice that he's going to be dismissed because he has done this act and he violated the code of conduct, the internal policies and regulations, and I provide this official letter and I'll dismiss him. But he has the right, the worker has the right to, of course, to defend himself, and of course the institution shouldn't stay silent if there is something that is abuse, let's say physical abuse. This is not only harassment, this is a criminal that is of course that has is considered to be a felony, and the employee or the employer should inform the, of course, prosecution and the authority that there has been an abuse, a physical abuse. And of course, this is all with the consent of the person who has been abused, whether a male or female. And of course, if it was the act only verbal abuse or verbal harassments, I take this procedure and the right decision by dismissing this person, and he has the victim, let's say, has the right to go to the let's say authority or court to file a complaint, a judicial complaint, let's say, for everything or for the violations or the penalties code you have mentioned apart, if everything has been proved. But if it wasn't proved, for example, some cases it's difficult to prove it, but we might have let's say a reputation to have finance from different donors. What can we do in this case? Because there is an article, if the person have made so many financial mistakes, is going to be dismissed. So can we take both into consideration? And on the same context, if the worker committed a mistake which led into a financial loss to the stockholder, under the condition that he reports, that the stockholder reports the specialized parties of the incident through 5 days. And here the labor of code was clear of having a financial mistake, a real financial mistake. There should be approved, the days of approve, of course, doesn't mean necessarily that the mistake is done. There should be exist that the mistake exists, and I should inform or announce the legal party in the Ministry of Labor. After that, I dismiss the worker. After that, we send the messages for different partners and owners, the good intention that we have taken this legal procedure through this act. And when there is a decision, an administration decision, you have to walk, or you have to be abiding of the labor of conduct. Now we are expanding and giving different meanings as lawyers, as consultants, and the human rights or the rights of workers, and the experiences in courts and jurisdiction. This is speaking about mistakes, about, for example, the laptop has been damaged, sabotaged, these kind of objects or items, but also it's possible to be expanded in that there is an imminent mistake or a physical mistake that has affected the institution. So there is nothing to stop us from dismissing that person. And this expansion should have some execution. And of course, according to the labor resolution, alongside the internal policies and procedures and regulations that we work in the organization. Thank you so much, Mr. Muath. The last questions, I don't want to take long, of course. Article 55 speaks about the internal regulation. How can we read that in case there are some articles that has to do with exploitation and sexual harassments? How can we read this article, and to what extent everything mentioned is law abiding in case of dismissing a contract because of violating some internal policies? How do we deal with him depending on different penalties? Is it a specified penalties, or even whether he's a staff member, a consultant, or a volunteer? Your questions is very precise and important, Mr. Omar. Thank you so much. As a matter of fact, I'd like to repeat that Article 55 obligated each institution to hire more than 10 workers to have an internal law and policies. If I have 9, you are not abiding by the law to have. But I say, even if you have 1 worker, there should be an internal system, internal policies, because the procedures, dismissing the procedures because conducting any violations of it might not be accepted by the court if there is no internal policies. It's in the interest of each organization to have an internal regulation and policies, even if there were no more than 10 workers for the facility, which is necessary to have an internal regulation. This internal regulation might be stated inside or one of the some specialized systems or rules of code or code of conducts which is obligatory to the worker, but there is under one condition that there should be text in the contract that the worker has taken into consideration all these details and read all these details and understood all these details and signed the contract. So now, as a volunteer, a trainer, now we are speaking about the labor resolution. The labor resolution for the trainers, for example, or volunteer, a volunteer has only a voluntarily contract, which is a gentleman or a gentlewoman. It's an agreement to be more to have a gender. Okay, so the labor code states the relationship between the supervision and monitoring by the stakeholder or the employer. So the relationship between the voluntarily work has a discipline and research in different details and in different contracts, because this voluntarily work or volunteering work might be paid or unpaid. He might not be paying the minimum wage, for example, or he's only giving some transportation expenses. So what, as we always say, is that we have to be preventable. We have to prevent. There should be a legal consultant that know all these different cases. A training contract, for example, training contract is considered to be a working contract or what? So many cases should be disciplined. Now I am thinking about the relationship between the worker there is different, let's say, context between the Jordanian. If I would like to speak about Jordan, I might expand and speaking about different things. Hopefully, later we are going to take more discussion because it's very expanded. Thank you so much. And now we have questions that are in the chat box, and we are going some time to answer your requirements, of course, and we are going to answer through our guests. Because we don't have enough time, we will not be able to answer all questions or requirements. We are going to send documents of questions and answers and send it through our websites, and please participate in it. Now we would like to see the questions.
إذا إحنا ما كان عندنا هاي المعلومة بنسأل عنها، وأكيد ما بنبني عليها إذا
And of course, month is a good period. After that, it's going to be a 4 period because we don't have enough time. Thank you for the answer. And of course, we are going to provide more answers for different questions. So I have an example here. When it comes to wages, Mr. Muath, I'd like to answer. And of course, it is illegal. I couldn't understand the question. The question here, there are some organizations or institutions that does not, of course, go with 30 days. For example, if it was a 22 day, is it legal or illegal? In the Code of Labor, they do not deal with days, Ms. Heba. They deal with hours, the working hours, but the Social Security resolution deals with 48 hours a week, more than 48 hours a week, and it doesn't deal with days at all. But the Social Security resolution deals with days. If he has been working more than 16 days a month, he should be enrolled, or the facility should be enrolled in the Social Security. But the resolution law doesn't deal with days, only with the, let's say, vacations. Thank you, Mr. Muath. The application, when they, now I am speaking about the vacation, when they conduct the vacation. Okay, I would like to clarify something here. I apologize, Omar. We calculate the vacations despite the fact that days, it has nothing to do with the days. I work for a year, for example, a month in 48 hours a week multiplied by 4 is 260 hours, let's assume. How am I going to calculate? After 260 hours, you have an overtime. I'm giving you a salary at the end of the month, but working a day is divided into 8 hours. But the vacations, whether it's an annual, sick leave, is given 3 days if you are working for 12 months. by paying the wages, not only the work. So it's not complicated, but up until this moment, I didn't understand the question by Mr. Omar. Okay, we don't have enough time to answer more questions, but we are going to answer all other information. There is a legal question, Mr. Muath. The reference check or list as an institution. Let's say, if this institution asked me for a reference and I have provided another organizations, this is confidentiality. Legally, is this considered to be confidential? Does it affect confidentiality? If I had a clear question. If we asked from an organization that he was working on, and there has been a misconduct or any violation of the code of conduct, and it was confirmed and proved that there is a result, I might write, if I was asked through the institution that there is violations conducted by this person, just to maintain the confidentiality, a personal confidentiality, we report to you that there are some violations that has been conducted. You can ask it through the court or even the Ministry of Labor. But as well, I have to, let's say I have to protect myself as an institution, and I don't want to be in like different government that might affect my reputation. Thank you so much, Mr. Muath, and thank you, Ms. Heba, as well. You've been very supportive. Now you will have some questions in Arabic or even English. Please answer it. And this is just to make sure that our services are quality. I am Omar, the representative of Jordan SH. I'd like to wish you a great day. Thank you so much.